or anyone in the room.
Go ahead.
If you choose to enable your video or audio device during the meeting, as well as anything else or anyone else that may be in the background, could be recorded. The recording could include any opinions you contribute and anything you say about yourself. On occasion, chat within the meeting could also be captured in the meeting recording. Therefore, anyone attending the recorded meeting may have aspects of their personal data recorded if they actively participate or not. Okay, having a quorum present, I make a motion to open the meeting. Second. All in favor?
Aye.
Aye. Okay, so first on our agenda is it actually a hearing tonight?
It's our hearing on
It is a
the
hearing.
determination of applicability for wetlands.
Okay, so we received Moraga Storage's
No,
proposal.
it's not from Moraga. It's from our board. I received a RDA from Sean.
Oh, okay, I was confused. Okay. Determination of applicability for wetlands at 358 Colebrook Road.
Okay. I'd like to make a motion to continue the hearing until after the notice of intent is processed. Because we need additional information that we can get during a site visit. And this is Arthur Allen's recommendation also to let the wetlands issues be solved in the notice of intent process.
Are we going to consider this discontinued? Just say we're going to move forward and go to the regular June 2nd meeting?
I mean, I guess we could discuss that. Like, is it worth keeping it open or just closing it completely?
What did Arthur say?
Arthur said that he thinks the wetlands issues will be resolved during the notice of intent process, so.
So then he doesn't see that we need to keep this even.
Yeah,
That's what I'm getting from what you're saying.
I just think that having it open might maybe help us to make the case that those wetlands are still, there's still a discrepancy with those wetlands that hasn't been resolved, so.
That's a possibility.
Yeah.
So we could continue it and keep continuing it, and if it doesn't get resolved,
Mhm.
we could use it then.
Yeah, absolutely.
And if we don't need it, we can discontinue it at that point.
Okay, Sean, would you like to make a motion?
Yeah, I'd like to make a motion to continue the hearing at this time.
Second.
All in favor?
Aye.
Aye.
Aye. Thank you.
Next on the agenda is a discussion, DEP comments on Crawford Road project.
I put this on the agenda. I know I wasn't on the Conservation Commission when this project was being discussed. I
Mhm.
know this was,
Yeah.
the hearing was continued multiple times. I don't think,
This is for the
Yeah.
house lot right in the,
yeah,
at the intersection, right?
Mr.
Yeah.
Jimmy's house lot.
the small property.
Okay,
The planning board had concerns about just the wetlands impact. So that I don't think Bill from the planning board's here, but he told me that.
Bill
Oh,
is
hi,
here.
sorry, I didn't see you.
Phil,
Yeah.
did you come?
hiding back there, Phil?
Sorry.
When we had a hearing for that piece of property, did you attend our meeting?
No, I'm following up what the EP says based on the number posted on the site.
I think, and I saw DEP's comments on the DEA data portal, and I think you all probably already saw those and addressed those since there were multiple hearings. But DEP had detailed comments saying the requirements that they were suggesting. And if we could get like maybe a copy of the order of conditions to the planning board, and I haven't seen it yet either, but I know that a lot of, you guys had a lot of conditions for that particular project.
We did. We
Yeah, we
did it
did.
3 times. We had 3 different proposals. We had to take the best of the 3. And there was no way we could cancel it out.
What does Mass DEP say? Because it seems not, according to their text, it seems not feasible to put a house in there. When that they're virtually on that little stream. Lot is smaller than 1 acre.
We had a hearing on that and it had been determined that they were given permission to make it a house lot by the ZBA. That it was a proper house lot. And that's why we continued with our hearing. And we tried our very best to make it as.
And I think that, I'm not sure the ZBA had done that. I thought that it was something that,
It was
they-
years ago, the ZBA had declared that it was an applicable house lot.
okay. Because it wasn't, that wasn't done during my tenure on the ZBA.
No, I think it
No,
was,
think that it was-
it was long
was-
before that.
Yeah, and I think that, I thought there might have been an issue that even, I don't know, that that the lot was somehow, didn't require that, because I don't know. But I don't think we made any determination that a 1 acre lot, given that it's what the new requirements are, this board didn't weigh in on it.
No,
The ZBA in, I don't know, however long I've been on ZBA, hasn't weighed in on it. Whether ZBA before that did, that's,
The planning board had no input to the ZBA review. We had written to the ZBA for the planning board saying it's way too small. It's not even a pre-existing non-conforming. It's never a legal lot.
so I know the work that we did, we put in whatever conditions they were. There was, I think, 2 or 3 different options that we discussed for the septic system. And then I think we ended up doing one that they've got to build it, and it's like a pumpable type of, or whatever it was, that it was
right.
I know that's what they ended up with. But if
right.
you need a copy of those conditions, or
I have downloaded conditions from DEP.
Yeah.
Okay.
And I've seen a plan somewhere in the last year that showed bringing in loads and loads of fill to build a banking down next to the river to be able to put in a septic system. So it just seemed to us that it's a little bit stretching to make that, term that as a buildable lot.
I think at the very beginning, we didn't think it was a good place to build.
no,
yeah, but I think we had said
Residents
that's not
didn't either, but they had the
commission's.
paperwork that said it was a buildable lot.
Yeah,
And we had been given that paperwork, and what could we do?
That lot has a long history too of
Yeah.
someone way back in the beginning, somebody in town that owned that lot for a while. Dug up an area and put in gravel, salted the lot for an area that it could perk. And nobody caught on to that until somebody tried to do a perk there. And when, I think Fred Carey said, this isn't original earth here, this is the fixed rate.
I can't speak for the ZBA because I wasn't on the ZBA at that time. I remember the problem that they were having with it. And it was my understanding that at first it was denied as being a buildable lot. But then we found out that there was another decision later on that said that, yes, it was a buildable lot. So they must have taken it one step further from the ZBA. I don't know. Again, I wasn't there for the ZBA and
yeah.
neither was Carl.
So the printout from the DEP says it should be redesigned.
We had them redesigned
them
3
redesigned.
times.
When is that? When are those notes from?
But today,
They're from today, so they're printed off today. I mean, are you able to tell when the DEP entered the notes? Did they enter them today, or are you?
no, this is downloaded today.
Oh, okay.
So there's nothing, I don't find anything newer than this. So the commission is supposed to field verify the wetland delineation. And there should be a deed restriction that memorializes the limit of alteration riverfront area. And there should be permanent markers at the edge of ERA. The commission should refrain from closing the hearing until all updated materials are received.
Was this material
Hearing on this.
provided to,
Don't recall.
yeah,
don't
I know this
that
was-
either.
Like Zach did a lot of work with this.
why don't we,
Um,
why don't we pull that and then and does anybody know the status of what's going on at the property? I mean, I'm in the neighborhood. I don't see anything going on up there at this point.
I know that, if they're going to start cutting any trees, they're going to want to do it this spring, I would think, in the summer, but I have not any.
I gotta figure this out. Hold on a second. Someone's
As
entered.
moving forward, I haven't even heard anything. And it's been 2 years since, almost 2 years since we worked on that. And we never heard it. I never heard anything sent to me from DEP.
Were the butters part of the ZBA or the Concom?
They all came to the Concom.
Yeah, they were here at that. I don't,
And they didn't understand, as we didn't understand, was how it got, where along the line it got determined to be a buildable lot. Because we didn't declare it. It was cleared already for us. So we just moved forward with what we had, but we kept saying, we kept questioning.
and
them.
isn't it?
That's why we had them redesign it 3 times.
Yeah, isn't it DEP? Don't we usually get, we don't have to go onto to a website to track down what DEP is telling us. They send us
Send it to
email.
us.
They sent it directly
Correspondence.
to us, and I don't recall any restrictions from DEP for that particular lot.
But
I can research it.
yeah, let's take a look at what they have on the website and then we go from there.
But even after we issued the order of conditions,
Mhm.
we got nothing back from DEP saying that they were going to supersede us, which they could very easily have done.
Yeah,
They have 10 days to supersede anything that we do. And that wouldn't certainly have not have been the first time that they've ever done that to us, which is fine. We always go out and visit with them if they need to come. So I don't understand why we're getting crossed over, who got all this information, but yet we didn't, and we were doing the orders. This, you know.
Yeah.
Our
so
town-
maybe that they like the modifications that we did. And that's the end of it for them, but maybe not. So it's worth
Yeah,
checking
that
out.
could have been entered before we had them redesign it. They had 3 different designs. We had them redesign it 2 times.
Yeah,
So
So we don't
maybe
know
those
which one they're
comments are,
talking about.
do you have the number that you looked up? Just so I can look it up and see what it's saying.
Yes. 252-0152.
520152.
0 Crawford Road. Going back almost 10 years, I think, planning board wrote to the ZBA when this was first in question, saying planning board opinion is not a buildable lot and by any stretch of the imagination. So time goes by, boards forget.
Yeah, I remember we did question whether or not
We did.
it was buildable, and I think he said, I mean,
He sent paperwork that it was declared to be
Yeah.
buildable. And I don't remember whether it came from a court decision or some other place. I don't recall. I'll check through.
Mhm.
Any other comments on the Crawford Road project? See what we come up with.
okay.
Okay, thank you.
Thank you. Okay, next on the agenda is the discussion of the town of Oakham wetlands protection bylaw.
Yeah, I wanted to take an opportunity for a session for public input. I don't know if does anybody here need a copy of the wetlands bylaws or want a copy? I have a lot.
They all
Okay.
need a copy. Everybody that can get a copy should get one.
Yeah, this is the current draft. Legal counsel currently has it. They're viewing it.
So this is,
The more people you can give copies to
Yeah,
before the hearing.
okay.
better you will be and the less questions you'll be getting.
Absolutely.
And,
Yeah.
and we should have outside of the Conservation Commission, a separate meeting, correct? For the general public to.
Just a general public meeting.
I think
Okay.
once some legal counsel comes back with the reviewed version, I think, I was hoping I would have it by now, but, you know, gee,
Right.
it's a lot to review, so.
Mhm.
But yeah, I think, it may not be the annual town meeting, it might be a special town meeting that, these are voted on. So in that
Yep.
case, we have a little.
So
bit more
long as
time.
you have a regular hearing for everybody, is notified, you have an agenda to go with it,
Okay.
and you have a notice up in the newspaper
Okay.
and a notice printed, not just on Facebook, but
Mhm.
especially where everybody can get a copy. Facebook does not go to everybody.
Yeah,
You
absolutely.
know, and then that has to be done 2 weeks before the big meeting.
Okay.
And then everybody in town, you know, you would want to put it on the sign out in the front. You would
Okay.
want it maybe 1 or 2 weeks in the Barry Gazette, so everybody has attention, but I know not everybody gets the Barry Gazette.
Yeah,
But those that don't have the YouTube and all of that,
yeah,
they usually have the Barry Gazette because that's how
That's
they
how they
find
get their
out.
news.
Yeah.
That's how they get.
But
the
we
news.
could also, maybe we could do like a mailer
okay.
Oh,
Yeah,
to
absolutely.
everyone in
Absolutely,
town.
we could
It
do
doesn't have to
anything
be,
like
you
that.
know, the 5-page thing. It could just be the thing that you have on Facebook.
Okay, yeah.
I'd be willing to, you know, would Conservation Commission pay for the mail? Yeah, okay.
That would be helpful.
I would help, you know, fold them and
Mhm.
stamp them and, you know, help do all that stuff.
Okay,
I'm just reminding you that during budget season, we don't have budget,
Yeah,
but fortunately, we do have a wetland fund.
Okay.
And everything we do has to have the word wetland,
okay,
and then we can access it.
Bill?
okay.
This is designed as a general bylaw, right?
It is. General.
So it doesn't require any of the advertising process as a zoning bylaw.
Right.
If the required number of signatures, which you have done already,
Hmm.
then it goes to the selectmen for the warrant.
And town council is currently reviewing it. So that's just a draft right now. But the Board of Selectmen are in support of it. So yeah, I'm thinking once the copy from town council comes back, the reviewed copy, we'll be able to get it on a town meeting warrant.
It does not require notifying everybody and putting it in the Barry Gazette and all that process.
Okay.
Zoning bylaw.
Okay, it doesn't require that. Okay,
Well, please tell that to the Board of Selectmen.
Could you just like tell us the key points of like the overarching things that this would add that we don't have now?
yeah. Let me actually grab, I didn't leave myself a copy.
Don't have a bylaw, so
I know.
it adds a lot.
I know.
Oh, yeah.
Trying to figure out where this fills in gaps. That's kind of,
If you look in the performance standards, I think that will, so one of the big things that it adds is it adds a 50-foot no disturb zone and a 100-foot no build zone to all wetlands. And, a 100-foot no disturb zone and 150-foot no build zone to vernal pools. So that's a really big change because right now, all wetlands are only covered by a 100-foot buffer zone. And that's just a review buffer zone. Like we review what happens in there for wetlands impact. But a lot of the times people are still allowed to build really close to wetlands. Especially even if we make conditions, sometimes DEP will override those. So with these bylaws also, DEP can't be appealed with DEP. If we say you can't build within a certain distance of wetlands, that is just what people have to follow, no matter
that's a
what.
hard stop. That can't be overridden by DEP.
It can be overridden. I think they have to go to Superior Court, but it can't be overridden with an appeal to DEP like most developers do. It's much harder for developers to find loopholes to to building near wetlands and impacting wetlands. But most of the things in here are, they're just, additional protections beyond the Massachusetts Wetlands Protection Act. And they are protected under this bylaw, so it gives us local authority and discretion. And right now, we're just pretty much at the mercy of DEP with every decision we make, so. Also, there's a lot of things added in here. There's requirements for large scale projects. Anything over 2 acres of land disturbance requires additional filing requirements.
You know, the big thing for me was, and it looks like it's changed over some of the variations, but just the enforcement action piece on 9.2. Like right now, we're left to, if somebody's violating it, we all kind of sit around and are like, all right, well, what do we do? Like, what's our enforcement ability on that? In this, in where do you even look, right? Because people always want to know, like, hey, you're the commission and you're going to do this to us. Show me where that comes from, buddy.
Yeah.
So this will, you know, kind of spells out in 9.2, enforcement actions are authorized by a majority of us at a public meeting. And then I think we had put some other stuff in there before, but I like this. It shall be reasonable and proportionate in proportionality to the nature, extent, and severity of the violation. So, you know, if we have somebody who, you know, went out and in their little yard just happened to, you know, put a little bit of fill in an area and is like, listen, I didn't know, you know.
Yeah.
No, okay, we're going to undo what you did. There's not going to be anything other than just redo, get it back to the way that it is. Versus, you know, maybe we have somebody who is in the industry, knows that's a violation, goes and puts truckloads of fill into something in the dead of night. We're going to be like, no, that's a violation. We can fine you for that, and we can do certain things.
Are the fines-
Based on that.
is the fine
Doesn't
schedule
say
here?
any.
Okay.
It does. I think before it didn't we have a fine schedule?
You did-
Yeah.
it was-
We did,
Yeah,
but
I think because I wanted that to be something that's open for discussion. And
Yeah.
there's also a section, regulations, section 11, that's saying that we can adopt implementing regulations later. So I was thinking that the specifics of like fine amounts and things like that would get determined then.
I mean, I like the idea of the board being able to, you know, you hear from the neighbors, you hear what the violation is. And if it's common sense that it's just somebody who,
Right.
you know, didn't know and can make it right, you know, I don't think we're in the business of trying to fine them out of business or whatnot, but just make it right. Put it back the way that it is. No harm, no foul. But if we get a bad actor to say, listen, this doesn't look like this was an innocent mistake. And here's, you know, I think we got, it makes it a little harder on those ones because I think we got to make findings and determine why they were a bad actor, that they knew they were doing this, and why we're going to impose
First
X
offense,
fine.
second offense.
Yeah. You know, you did something in the dead of night, you know, we got a call that,
Mhm.
you know, from a neighbor that there's trucks, you know, backing up into the thing. We're going to be like, hey, this doesn't seem like an innocent mistake anymore.
Yeah, and enforcement also has, section 9.3. Notice, the commission shall provide written notice of the violation and a reasonable opportunity for the responsible party to correct such violation prior to the imposition of fines.
Yeah.
So enforcement is huge. The peer review in section 7 is written into our bylaws, so we have the right to require third-party review at any time during the pre-construction, construction, or post-construction phase. So a lot of the things we're dealing with now, a lot of the problems we're dealing with the battery park proposal, this would kind of address. Solid waste is in here, a section on solid waste, the section that prohibits hazardous materials and industrial activity. So no bulk storage of hazardous materials within 250 feet of wetland resource areas. Ocam's wetlands are just really important, drinking water resources. So we just want to, yeah,
Since you mentioned 6.3 industrial activity.
Mhm.
Um. I'm not sure if I even have any suggestions or anything, but I just wanted to flag. The terminology itself is a very sensitive matter, industrial, because there is a statement in our zoning bylaws that says there are no industrial zones. You know, camp.
Yeah.
There and never has been, something along those
Mhm.
lines.
Mhm.
And in fact, there are, you know, I know that we can get commercial activity on properties with a special permit, but specifically industrial is actually still not something even by special permit that can be granted by the planning board. I know this is a real technical thing. I don't mean to get into the weeds, but I just wonder if that section should be looked at a little bit from a language standpoint, just to not insinuate that any industrial activity is and maybe is condoned, you know, in this bylaw, in conflict with another one.
industrial activity is defined in definitions.
It is? Okay, good.
Yeah,
I
so,
didn't see that.
so I was referring to that definition: non-residential, non-agricultural, and non-forestry operations that generate, store, handle, process, or discharge noise, emissions, vibration, artificial lighting, hazardous materials, or traffic with the potential to impact protected resource areas. May include, but not limited to, battery energy storage systems, large-scale solar installations, chemical processing, fuel depots, vehicle salvage facilities, and manufacturing facilities.
Revise it to substitute the word commercial.
Yeah,
Commercial activity.
I'd be more comfortable with that, just not even putting industrial in there as a, and again, as an insinuated allowable thing,
Yeah,
you know?
okay. That might be something that town council flags also. That's a good point. Yep,
In that industrial and commercial activity, definition. You have, although not limited to, but would it be worth calling out data center, since that's something that's on the horizon?
yeah,
Speak data centers in that list that you have.
absolutely.
And then I didn't hear, you may have said it, Sean, so I'm sorry, but on the bylaw, will the attorney have the review back so that you could put this on town meeting? Because that closes the warrant closes on Friday. I just didn't hear.
We haven't gotten the review copy back from town council yet, so I'm thinking that this is going to be a special town meeting, not the annual town meeting, because we need more time. Town legal counsel is reviewing it, and these changes, you know, these are small changes that we're going to run by town council before we get the final draft. Hopefully we get it back soon, but you know.
You're gonna get permission from Maribel to go to town council. You can't go on your
Well,
own.
the Board of Selectmen already sent it to town council. Yeah, town council has this copy right now, and he's been.
I know they requested that you do that.
Yep.
You know, give it to Maribel to
I-
send over.
Yep, I sent it to Maribel.
Okay.
When this makes it to town meeting, is it a majority vote or is it 2/3 or?
I think it
You
would
know-
be a majority vote at this time for this type of bylaw.
Yes.
Yeah.
Okay.
But I still think I would vote at one of our meetings that we do put out a notice in the paper. We need to be transparent on something like this.
Yeah.
And I'd more people that you get in touch with and say, this is what we're going to do, this is where we're planning, come to a meeting and let them know that
Yeah.
we're willing to go over some of it with them. You'll get more support,
Okay,
not just the 20 or whatever that signed your letter.
Yeah.
Notice.
absolutely. Okay,
I just think it's so important for everybody to look at it and understand it.
yeah, absolutely. Yep,
I have a comment on the enforcement part of it,
okay,
more reasonable. Leave it really wide open to different interpretations.
okay,
My recommendation would be to put a time frame. The word reasonable.
Okay.
What do you think about that?
Like reasonable.
Like reasonable?
I do.
Can you tell me why?
I think it gives the board the ability to, um, you know, it leaves it open to the board. So we're gonna be able to, you know, hear whatever the, alleged violation is. I think in the two extremes that I had talked about, one, the neighbor who puts a little bit of fill in an area that they shouldn't put a fill into, and we decide, you know, all that we're gonna do is, you know, just return it back to its original state and everybody goes about their business. That's reasonable and proportional to the nature and extent. And then the other side of, you know, we're gonna fine you $10,000 for bringing your trucks in the middle of the night and dumping it. Again, reasonable. It doesn't put a cap. It doesn't put anything on there. And it also gives the aggrieved party, so that homeowner who thinks, oh, you know, that's too harsh, you can go and challenge that. You want to go and, you know, we go to court and say, they're so unreasonable, this is not correct. You know, go ahead and have at it. And it gives them a chance to do that.
Also, if you put like a monetary value on it, say $1,000, somebody might look at it and say, well, this is worth me doing for $1,000.
I'm not talking about monetary limitation or anything like that, because I agree with you in that position.
Yeah.
But the timeframe.
Oh, that's okay.
What do you mean for a time frame on it? Because as it reads, it says enforcement action shall be authorized by a majority of the commission. So we'd all have to, a majority of us would have to agree. It'd have to be in public and open. And whatever this penalty is, it shall be reasonable, proportional to the nature, extent, and severity of the violation. So this time frame piece that you're talking
I
about,
think
what is
he's
it?
talking about 9.3.
9.3.
The commission shall provide written notice of the violation and a reasonable opportunity for the responsible party to correct such violation. Is that what part you're talking about? Okay.
Yeah, so, okay, all right. So on that one, again, I always like reasonable because I like just being reasonable. The commission shall provide written notice of the violation and a reasonable opportunity for the responsible party to correct such violation. So, you know, I think of a case that I had at one point where it was that I had a homeowner in the front of the yard was a little wetland and they were doing yard work and they put stuff into that area and they said, oh, you know, that's a wetland. You can't put that type of stuff into the wetland. And even to undo that, it required that homeowner to hire, you know, an environmental engineer type person to come in and say, all right, this is what we're going to do, and come up with a plan for taking out essentially what was yard waste out of an area. And then where you're going to put the yard waste, we got to pick another area in your yard where we're going to put the yard waste. And then we'll all come back and agree that this is what this wetland area looked like before, and it's all back to what it was. And to say that, you know, you think, boy, that could be done in 30,
Everything, right? Marshall? Oh, yeah.
that could be, that's all right. I'm just going to mute you for right now. And if you need, we need unmuting, you can hit the raise your hand. If I knew how to do that, I'd do that. So first, oops, I didn't kick him off for the record. So to put, you know, if I think that if that person was in that situation and the bylaw said that has to be done in 30 days, and there was no way that that really could practically be done in 30 days, I wouldn't want to be that homeowner. So I'd want to be in that situation. I remember going to the board and saying, hey, we're going to hire somebody. This is, you know, first, you know, a homeowner doesn't even know who an environmental engineer is. Let's go scope out those people. And we went and found somebody. And then we're trying to find somebody that's not costing a lot of money to take yard waste out of something. And we said, all right, we got this guy and this is the plan we can put in place. and we worked with the board and we came back every month and we said, this is what progress we've made and this is what we've done. And then, this is the plan. And then, we'll execute the plan next month. And it got executed and done and everybody was fine. And so I'd want us to be able to have that flexibility to do that too. But I think that part of that too is, you gotta then, the board members at some point will know that we're dealing with somebody in good faith who's doing that. And at some point, we may end up with somebody who is got you on the treadmill,
Right.
going round and around.
We can, if we determine it's not a reasonable amount of time, we can start imposing fines.
And we can say, listen, we'll give you 30 more days. We've given you a chance to go and do this stuff. And we can then set, I think, under this, a reasonable expectation. Come back to us in 30 days with what your plan is. Great. You did or you didn't. If you didn't, now we're dropping the hammer.
Right.
So that's my thoughts.
So on fines, if you do develop a fine schedule or some type of language around fines, you may want to also consider commenting on where the fines go.
Wetlands.
People will ask
Just,
that.
where would the funds go?
Yeah, because there's different options. And people will ask about that. My suggestion would be that you just say it goes back to the town general fund, but if it's not gonna go there, you wanna say that in here too, so people know.
Could it go to the Wetlands Protection Fund?
I'd send it to the general fund.
General.
Yeah,
Why would I give it to the town if we're doing the work?
Well, it's a fine and it's unanticipated revenue.
But it's still,
So people could see it as sort of like you guys are incentivized to collect more
Mhm.
fines if it's kind of going into some kitty that you guys have any.
they're gonna think that even if it's the general fund, we'll still have that, but I'd rather have it go to the general
That's a little
fund.
more of a buffer. if it
Yeah.
goes To the general,
Okay.
I agree.
but
Okay.
just something to keep in mind if you do the fine route on here.
And we can always take the money out of, have votes to take the money out of the general fund.
Or to fund us, if there's something that's needed, like, maybe a
What's
Best
happening
Park is
now.
coming in and we say, hey, we need some funds to work on that.
Any other questions or comments?
And we'll have more public sessions on this bylaw too.
Okay, we'll move on. Old business?
I don't know if you would consider this old or new business, but I think we all know by now that June 12th, we're going to be meeting for an NOI review for Moraga Park for the BEST program,
What date was that?
June 2nd.
June 2nd.
But you said June 12th.
I thought. you
Oh,
said
I'm
it was
sorry.
I think
No,
you did,
June
yeah.
2nd.
June 2nd for the Moraga NOI.
And we're really trying hard to think about, where we're going to hold this meeting. We were told we're to do everything the way we normally would do it. They are no exception. Okay, we already have a hearing at 6:00. They're at 6:15. I feel bad for the people that are at 6:00. I may give them an option to change their day if possible, but I mean, their notice is in and it's already in the newspaper. I would like to think, we could get everybody in here, but I think that's a very high expectation. The only other choices we have are the fire station, and I'm not sure we would get permission for that, and the school. And again, I don't know that we would get permission for that either, and I would be willing to try. But I've been warned at the schools that they don't have Zoom. Now, our special town meeting was not Zoomed. And the meeting we had, the meet and greet with the candidates was not Zoomed. But I would not like to have their notice of intent not on Zoom. I want to know what they're saying and I want to be able to hear it at all times. I don't know if they can hear me.
Okay.
And so I say, I will, if you agree, I will try for the school. And then I don't know if we can do anything about getting Zoom down there. I know I had asked Carl if we could do it on his telephone.
Bring a laptop. But I don't know if all of this is just internet based, then it is what it is. I don't know I mean, we could talk to the school about it. If they have Wi-Fi, then they have Zoom. I mean, we can Zoom on the Wi-Fi. And, but tonight I mean, if this room is packed and it's this hot and we got one AC going,
Yeah.
it's gonna be a long
We didn't
meeting.
have that AC yesterday. I got after them today because we did need one. We did
Yes.
need one. But
So-
that's what, I'm just thinking ahead saying, and we're really getting close in time, but where are we going to hold it? And I really think the school is the only other option, unless we do use the third floor at the town hall, but we know we can't get up there.
So keep in mind, even at the school, remember how much trouble the EFSB had, so
Right.
you could always have a satellite location, so you could fill up the room here, use the setup that you've got already, and have this Zoom running at another location, like at the firehouse, in the parking lot. I mean, we can do
It's
what
true.
needs to do to have everybody watch it.
Have no idea how to do that.
The fire.
But I have Sean and I have Steve that I'm sure they could
IT, right?
come up with something.
Firehouse does have a great Zoom setup in their conference
They
room,
do.
so technically they probably could
Okay.
help out. but
I know they
it's-
had trouble at the fire station one time. And I wasn't sure how
Yeah.
well they can do it, yeah.
Well, it's different if they have everybody in the bay, that's different than if they have everyone in their conference room with the
Yeah.
actual TV and stuff set up. And if it was a split location, that would probably make sense to do it in their conference room
Okay, we'll look into
as,
it then.
as a backup.
Yeah, yeah. But when the gentleman was here delivering us all their paperwork, he said, now, where are we going to be held? And I pointed to this room and he goes, oh, all right. And I warned him that there was a NOI meeting before him. And I said, I was hoping people wouldn't necessarily want to show up for that one, but they would want to show up for this one. And I told him, I said, how many people are you bringing? And he said he thinks he could limit it to 4. And I said, well, we can put them over there somewhere. But I'm pretty sure we would be pretty well filled up.
I think we're gonna need somebody to know how to do this, because if we have, 20 people that are off-site and 20 people who want to comment that are off-site, I don't know that the board members can be sitting here trying to figure out, all right, I'm gonna mute everybody, but I'm gonna let Susie talk now, and how that's gonna work. I think we're gonna need somebody to sit here and say, all right, we're gonna open it, to comment to the 20 people that are here and be doing this, and then we can hear what they have to say, and us taking, note of it and paying attention versus trying to,
Oftentimes,
To do this.
a meeting like that will have what they call a producer, and that's exactly what they do.
Right. So, go ahead.
It was a whole second setup that was used at the fire station when we have meetings there.
Is that the one they put in their meeting room though?
I think
Yeah,
that's-
But they had it set up out in the big area.
They might be able to move it out there and or something.
Talk to Tim and I see him.
So I have a question that I don't know if there's an answer to it, but we have a bylaw against what they're trying to do. Do we have to hear this until they have permission to do it? Can we deny them even listening to them and say, we have an active bylaw that says you can't do this, so we're not going to take time to review this until you have permission?
Their first 3 contacts from Rhineland Energy, we didn't deny them. We simply said there's a bylaw that prohibits it. We didn't say you can't come and present. And then after the 3rd contact, we said, planning board meets on this date. I'm in. They didn't. That's when they scheduled the open house in Barry.
I'm not saying deny them, just say we're not going to hear this right now until it's relevant, until you're able what
I think
you're
it's
presenting
twofold that we
is,
thought is that, but also the they haven't made their decision yet.
that's what I'm saying.
Yeah, so
So as far
Yeah.
as far as we're concerned, this can't happen right now.
That's a good point, since they haven't made the decision.
how do we know what the lay of the land is?
Right.
My only question, my only thought would be, supposedly, these were turned into DEP the same day that we got it.
That
And have
doesn't
we heard
matter
anything?
And
because-
DEP yet?
DEP should be sending us notice of their impression of this
There's no,
and a file number. Now, if they get that file number, then we're required. That's a question. Are we required then to hold the meetings? It's not that they had permission.
They can have all
To
the
do
numbers
the
from
job.
anywhere. If it's still against the bylaw of the town.
Yeah.
It can't happen.
Can I comment on this? So this was an issue that I raised a while ago, regarding the ANRAD situation. And a lot's changed since then. At the time of the ANRAD, I don't think the applicant was being very generous with the information about the project. In other words, it wasn't very clear what exactly they were proposing. And I understand that that's not necessarily required to apply for an ANRAD. But I kind of raised that issue after the fact, and I said, this commission, if an applicant comes to you with an illegal use and wants Conservation Commission action on it, what would you do? I think you would not accept, you would not engage in any type of illegal use. And just as an example, if there was a developer coming in and saying, I'm going to put a 9-story apartment building in Oakham, which is clearly illegal according to the zoning laws. We want to delineate the property. I'm thinking that the Conservation Commission would say, I don't think we're going to be doing that. It's not even, this isn't even something that's possible in town.
Right.
What's changed since the ANRAD is that the Morega has said on the record that this is an industrial use project. In both the evidentiary hearings and on your NOI application, they checked off industrial. Today, as we stand, there is no industrial use permitted in Oakham. And so I interpret that as this is a request for an illegal use today. If the EFSB overturns our bylaw in sometime in the future, that's a different story. But where you sit today, I think that they are still coming to you right now, explicitly now, asking for delineate or, a notice of intent on what is illegal in Oakham where we sit. So that's my take on it.
Do you think it would be wise to consult legal counsel to get an exact ruling as to whether or not we need to do that? Because they keep coming at us saying that, we didn't cooperate. And I don't think we want that intention to continue. And perhaps I know there's not a lot of money for legal counsel right now, but I think it would be very important to just clarify whether we have to do that or not.
Right.
And then if we don't, that's going to save a lot of trouble for now.
Agreed. Yes.
Sounds good. How would we bring that to legal?
Well, we gotta go through Maribel, right? Yep. So I think that's a perfectly good question. So one question email, town council can weigh in.
I think perhaps
Can do that
you phrase
before.
that however you want that question to come to Maribel.
Yep.
You should be very specific, exactly what you want to know so that you're getting the answer correctly and it's being presented to council correctly as well.
And they're gonna be here for the meeting as well. So they're coming for the meeting.
town council is gonna be here.
That's what I was told, right?
Yes.
Town council will be here,
That's what I
so
was told.
I would like to meet with him before. That would be
That's
good
it.
if
Again.
he's willing.
I would love to meet with them and then do what, but it is what it is. If they're gonna be here, I mean, these are great questions that deserve answers.
There's a lot of reasons to continue the hearing past June also, and I think we should bring all those up. I
Yeah.
have a list of reasons, so.
I mean, it's gonna be
Oh.
continued anyway, but
There's a bunch of ways to continue
yeah,
that. The problem is we have to have their signature allowing us to continue
Okay,
their hearing.
okay.
Correct. So there's all kinds of questions about that process too. What happens if we hit a deadlock? Oh, that's it.
One more question about the legal aspect. Is there any way that you can be sure that you are getting an answer back from council? So will somebody follow back on that? Because there's not a lot of time, as Lucy said. And there's going to have to be preparations made if we do indeed need to take part in that. In a wide hearing. So I sometimes I think things happen and there's no follow-up. And I think this is something that we can't let slide. It's just my opinion. I don't know how proactive. I don't know if it's your responsibility, Maribel's responsibility, select board, I don't know, but somebody needs to.
We've been made clear that we don't have we don't have a lifeline to town council.
No, we're not going to
But
this.
yeah, so
Exactly.
it is what it is from, you know.
So setting that whole issue aside for 1 second, I also had a question about the enforcement order that was issued. Has the commission gotten a response from them yet on that? And if so, if not, or if so, how does that also factor into, the upcoming hearing?
Got no response at all from the enforcement order.
And I think we got return mail
Yeah,
today?
this is part of the legal process, so I've been waiting for this. This is huge. But yesterday, I just sent all of these documents to, what's his name? Yaniv Cohen, from BHT Properties, because he's the registered, agent for Zavel Properties, so. We have to wait for that to come in too, but I'm ready to take the next steps to get a search warrant for the property, but we just need all of these documents first. It's taking a long time. But I think that's a great reason to not
Great
continue.
questions to have for the applicant when he comes here.
We have
Why haven't we
opening.
heard from you? What steps have you taken to clean up?
Yeah.
Mm.
The DEP also said that the cleanup had to be in the notice of intent, and it's not. So that's one big point.
okay, so we need to
All right.
get a hold of town council through Maribel with an email. Let's just go through so we're clear. So first, are we required to hear them, given that there is no industrial business in town? Given that there is a bylaw,
Yep, it violates multiple town bylaws, so it's not something we would normally. Also, the open enforcement order on the property.
so no. No response to the enforcement.
Yeah.
Anything else, Carl, you think we should address?
I can't think of anything off the top of my head. I think that you're right, town council, what's the next steps for an administrative search warrant? It should, and part of that is the town's gotta, authorize that we've gotta, file some action, either in housing court or whatnot, to say we're gonna go enter the property and do this. And that's gonna involve sending someone down to the court to do the filing and all of that. I don't know that, I think that's as far as we can take it, is we've gotten to the point that We told them we need access to the property. They haven't responded. Falls in our court. Our court is great. Somebody's gotta go to court and say, let these people on.
And I intend to go to court with these documents as soon as everything comes in.
Yeah.
Zovel Properties in Fort Lauderdale, Florida, that is an invalid address. That's also on their application, their notice of intent. So that address doesn't exist. Everything we send there gets kicked back because,
So I noticed on that in about 90% of the filings, it's that address. And then in one random place, they've got that address plus a suite, and it's like suite 207 or something. Whether or not the addition of the suite would change it, but I'm not a postal inspector. I don't have the time and energy and ability to go and check if they're giving us full and complete address information. If they're gonna put it on their application as this, we're gonna trust that it's that. And
They have a whole network of shell companies at that same address, 5555, whatever avenue.
Yeah.
It was Avenue in Lauderdale. And there's a variation of it that's a different 5555, different street name, same building.
yeah. So, yeah, I mean, I got 10 minutes of questioning for the applicant about that.
and there's some other things in here that I noticed that are inaccurate that we can bring up. I have to highlight all of them. But we have the right for third-party review too.
Yes.
It's a new notice
So
of intent.
like all that stuff doesn't need to be in the email too.
No, no,
I'll just highlight the zoning. The violates the bylaw.
yeah. And yeah, I'm sure. That would be a really important discussion to have with town council. I'm sure that he'll want to engage with all of our questions.
I'll
I
send
would
you
like to
guys-
think too, we could check with MACC to see if we can use some of the wetland fund. So to pay for an email to town council,
Yeah, okay.
but again, I know everything has link
Yeah.
on it, and if we could put it that way, maybe they would say, yeah, that's okay.
Yeah.
Because they have their own lawyers and they can tell you whether it's okay or not, but that would be a good thing to do.
Okay. Yeah.
Because I wouldn't mind, we don't have a whole lot of money there, but
Yeah.
to me, that's a good use of part of it.
Wetlands questions. Yeah.
So how would I write this email? Who would I address it to? The town,
I think we go to Maribel, right?
and ask Maribel to ask.
Please
town-
forward this to town council. We're asking for an opinion on this question.
Okay,
We should give her a little more information than just writing a sentence.
What's the question that we've got?
so there's no industrial zoning in town. And we have a bylaw against
Against
battery operated
storage cars.
storage.
And
do we
the-
have-
And no decision has been made by the, whatever it's called, that regarding their petition. Is this premature at this time? And do we need to consider this?
Are we required to hear?
Are we
it?
required to have a hearing on something? matter?
Can DEP tell us, yes, that's been submitted to you, you have to take a look at it?
And yeah, maybe if it's been submitted to DEP and a DEP file has been set up, does that require us to
Oh.
now act on this?
I don't have a file number yet. I haven't heard anything from DEP on this at all.
I checked today. There's no file number or comments yet.
Okay.
They always send me a little flyer, an email to tell me, yes, this is what we've done and this is what we think. And I haven't received any. Any part of this, have I heard anything from DEP? except when I couldn't get hold of them when I wanted them.
I'm sure they'll comment on this one. They said they would. Also, the applicant pays for third-party review. I forgot about that, so we don't have to pay Arthur Allen. We
Right.
shouldn't have to pay Arthur Allen. for
No,
that.
we shouldn't have to, but I wanted to protect us that we could. But
Yeah.
we still want him no matter what.
Absolutely, yep. I reached out to him too, so he's not tracking everything
Good.
that it's coming up.
Anything else?
Yeah, I would like to get those answers quickly so I know whether to get the school or the fire department.
Yeah, I mean, I plan to at the latest send the email tomorrow. I'll send it to you guys first.
Okay, just send us a copy, yeah.
And just to encourage you guys, I don't know if you got your ocam.mass.gov email set up, but yeah.
Yeah.
Get that, and that's something that you can get through Maribel,
Okay,
and it'll help keep your private stuff private and your stuff that you're doing here.
You get OCAM,
I get it's Carl
you get
Huntley at
OCAM, you get
OCAM.
Conservation Commission.
I get
actually.
Conservation Commission.
Do you also get Conservation Commission?
No,
I
do,
do,
see
and he
everybody's.
does.
I see like the fire department emails. I see.
Yeah, you can get loaded up
Yeah.
with some things, yeah.
I need less emails, so I'm happy with just
Right.
Carl.Lindley
Yeah.
at OCAM.
That's why I wasn't sure, so when I write for just conservation, I know what I'm sending to him and I'm going to get a copy of it. I always set yours separately and I always send yours separately. But you all get everything that I have,
Excellent.
because I'm not making any decisions by myself.
No.
Not on this.
Excellent.
What is this?
this is the documents I need to go to court.
And this will be available for the public. We're gonna leave a copy of this out. Is that right? Between.
I have a copy of this, and the article in the newspaper says that anybody that would like to take a look at it, please call me. I did put my telephone number in, and then I know to come up here because there's not somebody here all the time. And it will be in my little cubby hole that says Conservation Commission. It doesn't fit very well, but I can squeeze it in.
All right.
Any other questions? And you have copies of
Yeah,
the,
just make sure to reach out to these homeowners, because this, again, if this wasn't going on in our world, this is not a simple
it is not simple at all.
issue either, for a single family home, but that's somebody who's trying to come to town and build a single family home. And they probably deserve a lot more of our time than,
But that's why
Yeah.
I did warn their representative ahead of time, said I would take him first. He wanted to know if we would require a site visit, and I told him probably.
yeah, oh,
But we
definitely,
always
99.
do,
Yeah.
you know, so that would take care of him for that one night.
Okay,
That's why I gave them 15 minutes. They may take 20, 25. But I will give them the time that they need because
Yeah.
they're right.
yeah, so that might be the agenda there, is a quick survey of it, and we're gonna have to go send some folks out to look at it and then come back. And that will keep it at least on track for them.
Yeah.
Okay, that's all I have.
Any
And
other questions or comments from anybody?
you meet at 7. Well, we already went over. And we'll let you have the Zoom. We'll have to shut our portion off.
All right, so that will take me an hour. See here.
Great.
All
I
right,
make a motion to adjourn the meeting.
Second,
All in favor?
I,
I.
all right.
Yeah, in the meantime, we'll take a look at that.